This is Boomer Time, a proactive podcast for baby boomers, about baby boomers, and for people taking care of baby boomers. If that sounds like you, then you're in the right place. I'm Nancy Kogar, an elder law attorney and aging advocate, and this podcast was made just for you. Remember, though, the things we discuss here are not intended to be legal advice, and no attorney-client relationship is established by this podcast. Welcome to Boomer Time, everyone. I'm your host, Nancy Kogar. Thanks for being here today. And you know what? We have a full show for you today. It's all about probate, and I'm calling it the ABCs of Probate. You know, during my practice day to day, there are a lot of people that just are unfamiliar with what probate requires and or how it works, what's involved, what they need, how long it takes, how much does it cost, when do they get their money. You know, sometimes, and my colleague and friend Drew Clements is here with me today, and he does probate, so he's kind of nodding his head saying, yeah.
There's a lot of questions circling in that. Hey, Nancy, thanks for having me back again.
I'm glad you're here.
Probate's scary, isn't it?
Well,
but
it can be.
But it doesn't have to be.
Yeah. Well, sometimes it's like carrying a plastic explosive that you don't know whether it's going to go off. But most of the time, it's a peaceful thing.
Yes, it can run the gambit.
Mm-hmm.
And we've both seen plenty of easy transitions for folks and some hard transitions for folks.
Yeah, and it really depends on what you begin with and then how it will run through that process.
Right. Just starting with how do you find yourself in the wake of a loved one passing?
Right. So I'm really glad you're here because I like people to hear, kind of get a peek inside our minds, because we're dealing with these issues all the time and trying to make sense of some things that are complicated, try to simplify those. So that I think is really useful for people. And then, as you know, I was able to sit down with our clerk and master, Robin Miller, this past week, and she gave me a lot of great information about her perspective as far as probates, because the Chancery Court here in Hamilton County is the place where you have probates done. And wasn't only Robin, it was also her deputy clerk, Michelle McGill, who you will meet if you file a probate down at the court. Canvasser. And Annie Fricker. And Annie is a one of a kind. So.
She sure is. They're all great people, and they take really good care of both the people going through this process, but they take good care of us attorneys too.
They do. Yeah, they do. So I know I probably got on their nerves once or twice, but they're very forgiving.
Hey, you and me both.
So, and we call Annie the dean of the probate court. So I'm hoping we're gonna hear from that interview first, and I'm hoping that folks find that helpful, because these are your public servants. You know, they're in these positions to enforce the law. They don't make the law; they're enforcing the law. And then, you know, kind of hear what's the basics of probate, touching on the process itself. And then we're going to talk about some of the things that come up, what you need. And then continue on with some of the things that we deal with. So
certainly some practical tips on how to best prepare.
Yeah. So let's listen to what the clerk and master has to say.
I'm very interested to hear this.
Oh, good. All right. Well, we'll be back, and hope you enjoy this. Thank you all for joining me today. And with me is our wonderful clerk and master, Robin Miller, and her deputies, Michelle McGill, and then the dean of the probate court, Annie Fricker. So thank you all for being here. I really appreciate it. And as I've said, my whole point of doing all this is to try to better educate people about different processes. There's a lot of misinformation out there, so I like to try to get that out, and then it's getting a good response, so I'm glad about that. So I am very glad that all of you have joined me, and of course this is a busy place.
Yes, it is.
Yes.
Very.
Yes. And Robin, you have multiple kind of tasks, but today we're talking about probate.
Yes.
So I invite, whoever wants to take this on, or you might all have something to say about it. But for someone that doesn't understand what probate is or what the purpose of it is, what would you tell them about that?
Well, essentially, when an individual dies, he or she may own real estate, bank accounts, investment accounts, personal property, all kinds of things, vehicles. And if those, the titles or deeds to those assets have beneficiary designations, or if they are owned jointly in some fashion, they will pass on that person's death to those beneficiaries. For example, if there's the family home, the farm, and it's owned by a married couple or tenants by the entireties, on the date of the person's death, it passes to the surviving spouse. Bank accounts can pass if they're joint bank accounts. You can have beneficiary designations on 401ks, pensions, investment accounts, any kind of bank account, annuities. So you may not have to probate, but if you don't own property jointly, or you only own some of your property jointly and not everything has a beneficiary designation, then you will probably end up in probate if your assets are above $50,000. And essentially, there's some misconception about probate, such that if you die without a will or you go to probate, the state takes your money, and that's just not true. Those are all misconceptions. It truly is to pass title to either the heirs at law, if there's not a will, or the beneficiaries under the will.
Right. And like you said, it's treated differently if there is a will. That testate versus intestate. And I think I look at a will as kind of instructions for what you want done with your stuff after you're gone. So if you don't have a will, then the state is making those instructions. But
that's exactly right. There's the whole intestate statutes that if you don't have a will, then who gets the property? The spouse, the children. If there are no children, you go further down to the heirs at law. So, but there's a statutory scheme for that. So, but still, it doesn't go to the state of Tennessee or a sheet to the state unless there's absolutely no one. And that's very, very rare. Somebody has somebody out there. But it's a good thing to have a will. It really is. And you don't have to go to a lawyer to get a will. If you can draft your own will, but in your own handwriting, and have it signed. But it's not the safest way. The safest way would be to go to a lawyer and get a will drafted so that exactly what you want done with your property is done.
Right.
And that's the thing, people will come up to us all the time and say, but I'm the executor and and I will say to them all the time, until it's probated, this is the wish. This is what they want to have happen. But until you actually present it to the court, you are not anything, and you don't have any authority to do anything until we actually give you that authority, if it's needed.
Mm-hmm. And I was going to ask you about this a little later on, but Robin touched on this. Have you seen some really strange things come in here? I guess I don't want to use the word strange, but unusual, as far as handwritten documents?
Yes. I mean, I didn't see this, but I know that we have a will that was done on toilet paper. I have seen them on Post-it pads. I have seen them on scraps of paper. We have people will have a notebook. We had a notebook of some lady. She had all kind of notes in there, and then in amongst the notes was her will. So we have those, and we'll take them because it's it is their will.
Mm-hmm. And the legislative intent is to honor the wishes of a testator. And if someone has a handwritten will, what we do is they have to have 2 disinterested witnesses testify that is the handwriting of the testator. And disinterested means they are not taking under the will. So those people come in live and we have a hearing, and they will give testimony like, oh, this was my neighbor. I saw her grocery list all the time. I saw her write checks. She wrote me notes. I can absolutely say that's her handwriting.
Yeah. Important for somebody to know if they go that route, that's what they're going to have to do.
Well, we have had
Yes.
2 lately where we've had the wills. The children were the witnesses. So the children not only witnessed the will, then they signed the affidavit, and you can't do that.
No.
You cannot do that.
No, you have to have someone who's
Right.
not interested in the proceeds or the benefits of your estate.
Hence,
Exactly.
disinterested.
Yes.
Totally.
Yes.
That's what that means.
Yes.
Yeah. So, well, I know that also you all have quite a bit of volume that comes through here. So, what are some of the, aside from being able to establish a probate, what are some of the primary challenges that you see when people are coming in here and wanting to establish probate?
One of the things that we have to deal with is when the children or the beneficiaries or whoever come in and they don't have an original will. So this would be with a testate estate. They don't have the original will and they think it's the original will. And we must have the original will. And there are ways we can tell if it's an original will by the ink, by touching the signature, by the stamp of the notary. But if there is not an original will and all you have is a copy, you can file a petition to establish the lost will in probate. It's just an additional step to do that. So that's one challenge. Now, if the will really does follow intestacy, such that you've got 3 children and mom left everything to the 3 children equally, we say to that person, you don't need to establish her will. Unless that's something super important to you, just file it intestate and let the laws distribute it to you equally. So that's one big challenge that we have.
That's important to mention too, that you all are trying to serve the public and make it as easy as possible.
Yes.
While following the law too.
Yes.
Exactly.
Mm-hmm.
Yeah, we try to help them because they seem overwhelmed or something's not perfect, but there are ways that we can try to help them. Another one is when a person comes in with a Tennessee will and it only has one set of witnesses, signatures, and not 2. And there's a statute that lets us count the signatures that are on the will as the first set, and then you can go and get another set of signatures from those individuals. And there's actually a case that was published that says if you can find just one of those witnesses living, you can get the will established with just one witness, because it is a way that we acknowledge the legislature's big intent to uphold the wishes of the testator.
One thought occurred to me when you said that. That's a challenge that I see is, I try to encourage people not to do the one and done with a will, because if you wait 40 years, your witnesses might not be alive anymore, and the lawyer's not practicing anymore.
Right.
And that's been a challenge that I've seen from some of the older people that I've helped.
We've been to seminars that have suggested that you review your will at least every 5 years, and especially after there's a lifetime event, the death of a beneficiary, or a divorce or something like that, to look back and make sure that what you want done under Tennessee law is going to happen.
Yeah. So, not everybody follows the rules. And that's always a challenge. But I know I've actually had several episodes on fraud, scams, things that I've just seen a lot of people have been taken for a lot of money. And that's not without the challenges here in court too. Tell me kind of what some of the things that you might see.
What we see when there is kind of maybe a large family and there's no will, and the children are upset and not sure who's going to get what and what the situation is, you might have someone rush up here to open a will to understand or to learn at that time that they can't just open an intestate estate, or really, if there's a will, get it probated without having the person named in the document to be the personal representative there. Mm-hmm. And if it's the case of where there is an intestacy, and you have to have, under Tennessee law, the agreement of all of the heirs at law that one person can serve. And so we have to say we can't do this yet, because sometimes if one person comes up here and opens it, then they have taken in the past assets and disposed of them, consumed them, and it's very difficult to get that equalized with other assets if some have already been consumed. So we have to make sure there are declinations and that all the heirs at law are listed, all the beneficiaries are listed with current addresses, because they have to be given notice that the probate's been opened.
And that's that due process that we learned about.
It is.
Yes.
Yes.
And we have found in small estates, people are frequently dishonest and will just list maybe themselves when there are others. It happens a lot in small estates. Well, I'm Daddy's only
anything
natural
under 50.
child. That's under 50, right. I'm Daddy's only natural child. And they come, and then maybe Daddy's other stepchildren may come and do the same thing, and nobody lists the other. That happens. I mean, in small estates, it's the heirs. They're not honestly listing who the actual heirs are.
Yeah, and then once you get into a situation like that, it's harder to move forward because you've got something that's been done that's wrong, and then there may be a cause of action that results out of that, right?
Could be.
Oh, exactly.
Oh, there has been.
Mhm.
There has been.
The other big issue that I hear about is time. So, how long before I get my money, essentially? And that can take time.
It can. And even if an order, when it says immediately dispersed, it doesn't mean like right that minute. It could mean it could be the next day. I mean, because it's got to go through, the check's got to go to, through the bank, and it's got to make sure everything's okay.
Yeah.
And we've got the money and everything's there, and it still takes immediately, still may take a day or two, but it doesn't take the 30 days.
Right.
If you don't have immediately, then it will be, it can be 30 days.
Right. I mean, good practice would be not till after the creditor time period has run, which, could be like 5 months. It's 4 months, but then you've got that exception month afterwards. And I know, and the chancellor doesn't like any estate closed prior to a year because we have had some issues, or we had a creditor file a claim 11 months and 3 weeks after date of death. We'd already closed the file. Doesn't mean that they have to wait for a year to disperse the money, but they certainly need to wait till after the creditor claim period has run, just in case.
Right. Because, every time I think I've seen it all, there's always something else that comes up.
I know.
Yeah.
And sometimes you may not know who the creditors are, and I know the statute says, known or reasonably ascertainable. You may not know. Something may come out of the woodwork that was a legitimate claim, or they get a huge 10-year.
Yeah, and I do get a lot of questions about the 10-year as well. Usually that comes in the format of, they're going to come back and take my house. My house, meaning, hopefully the individual that I'm working on the will or the estate planning for. But that I also hear that from the kids. Are they going to take my mom's house? They want it. Yeah, and I usually say that's not a good retirement plan. And there you have it. And I really appreciate, special thanks to Clerk and Master Robin Miller, who I enjoy practicing before, and her deputy clerk, Michelle McGill, and of course, Ms. Fricker. She is the dean of the probate court. So, good stuff in there. I hope that's helpful. Most people don't get the opportunity to hear from people that are doing this on a daily basis. So that's why I like having you here too, Drew, because we have to deal with these things. It's almost,
It's almost like second nature for us, but it's very unnatural for anyone who hasn't gone through a major death in the family like this before.
Right. They're looking at the same process. We're looking at the same process, different circumstances, but trying to figure out where it fits. And then there's the timeline that follows wherever the circumstances drive it to.
Right.
So I think that was really helpful. And I know you probably feel this way too, but I really like it, practicing probate. You feel like you become part of the family in some ways, because you learn about the person that's passed, and they always have some story. And then you're in the thick of all the items that need to be administered, and the people that they're going to, and the things they left behind, and circumstances that need to be resolved. And it requires a real compassion, patience sometimes.
I think it takes a delicate touch, and oftentimes you find people in the midst of this grief, and then as the process goes along, you kind of see them kind of closing that chapter of their life, and then they're kind of looking to their own family at a certain point. And, we really got it good here. Yeah.
Don't you find too that one of the most powerful ways or lessons people learn from probate is, I got to get my stuff together.
I think the biggest catalyst for estate planning is to see the probate process up front.
Yeah, absolutely. Robin was talking about some of the challenges that they face. And one of the things that she mentioned that I thought was interesting was determining whether something is a will or not. I've talked about that on some of my episodes, where Tennessee's a strict formality state, so it needs to fit all the criteria under the law. But they get some interesting things there. Andy was talking about a will on toilet paper, and
there's a whole galaxy of different things that people purport to be a will that may or may not be a will. And I know you've seen a dozen things from different programs online that people may try to do it themselves, and sometimes that works and it's great, but sometimes you just miss the mark there.
And I know you've done this before too, but you can make an attempt to try to cure a will, and I've chased old witnesses and tried to track them down, and
that is a fun adventure sometimes. I had a call to a guy in Arizona a couple months ago and said, "Hey, you missed a thing. Fix this." So we got it taken care of.
We're glad you're still alive.
Yeah, thank goodness.
So you and I talked about this, and again, it's second nature for us. But there's a lot of verbiage that people are not familiar with, and Robin talked about some of that, when a probate case can be testate or intestate, and really the key issue is whether you have a will or not, an enforceable will. Yeah.
Right. And I'm sure she covered this already. Testate is with a will, intestate is without a will. Either way, you can still end up in probate with a will or without a will. And then you kind of get into, what is probate and why do I need it? And, I tell folks the simple answer is it's just the process of transferring assets from a deceased person to their loved ones and to whoever they may have directed it to if they have a will, and whoever their heirs at law are if they didn't have a will.
Right. And, it's just the way my brain works, but I try to explain if it's got a payable on death designation or it's got a beneficiary, it has somewhere to go. If it's a joint owner asset, then it moves to the survivor. If it's a payable on death, it goes to that person when the death occurs. It has a beneficiary designation, then it goes to them. Problem with some of these assets is they don't have anywhere to go. So that's when we find ourselves in probate often.
Right. I had a law professor in law school who said it's like Christmas morning. Everything that has a name tag on it under the Christmas tree, that's a non-probate asset. That's your payable on death. That's your life insurance. That's oftentimes investment accounts. Every present under the tree that doesn't have a name tag on it, that's what's going to go through probate.
Yeah, I like that. That makes a lot
I've
of sense.
always thought, man, that's great.
Yeah. And one of the key things about estate planning when we do this is to make that probate pot as small as possible, right?
Right.
So,
Right.
Yeah. Because in probate, you've got creditors, you've got statutory requirements, you've got an opportunity for a contest. If someone's not happy with
Right.
the way things shake out.
I think the more that you can button up on the front end, the less hiccups and speed bumps you run into on the back end.
Because those ultimately cost money, right?
Yes, yeah. You've got filing fees. Sometimes there's a bond that you need to do. Oftentimes you're going to have an attorney help out, which can sometimes be expensive. Sometimes it can be cheap. And there's just a whole lot of unknowns.
Yeah.
And I think that's the biggest thing that troubles people is just a lot of those questions of how long does this take? How long am I going to spend? What else do I have to do? Why isn't it happening instantaneously?
Yeah, and you can get into big trouble if you're not doing what you're supposed to do. So.
Oh, yeah. Just because you've got money coming to you doesn't mean you can spend it right away necessarily.
Right. So, and I want to talk more about some of the issues and circumstances we see coming up, and hope you'll stick around for that.
Certainly.
Oh, excellent. Certainly. I like hanging out with you, Drew.
Likewise.
So, well, I hope that hearing from our clerk and master and her staff has been extremely helpful to you today. Maybe taken away some of the mystery of what probate is all about. And Drew, you are very helpful in, kind of talking through some of the things we deal with and trying to make it into an understandable form for the people that we serve. And we are servants, and I enjoy that. So
I tell folks there's a great attorney in town. His law firm is Trailhead Planning. And I say, look, I just see us as, look, we're trying to guide you through this. It's your goals, your aspirations. We're just here to help.
Yeah. And it's a real privilege.
Mm-hmm.
So, well, thank you for being here today again. You were very popular when you did the last episode with Medicaid Asset Protection Trust. So,
I aim to please.
Yes,
thank you for having me back.
Good stuff. So go back and listen to that if you haven't heard that one. It was a real popular show. So thank you, everyone. And thank you, Drew. And we will be back next week, and you're going to hang out with me so we can talk about circumstances involving probate. So thanks for doing it. Yeah, thank you. So bye-bye, everybody.